Okay, let's move forward to how to work with rental properties. I put this picture here over the weekend, and I was hoping it wasn't too inappropriate. Does this renter look familiar to any of your associations? I hope not. Okay, so how do we effectively deal with rental properties? With the downturn in the economy, we saw more rental properties in Arizona, and it wasn't necessarily a bad thing, right? Because what's the alternative to a rental? Possibly a foreclosure, where there's nobody living in there. It takes forever for the bank to foreclose. So we've seen some increases. Tenants can be good. I taught a class on this last week, and somebody got up and really gave it to me, saying, you're painting tenants in a bad picture, and that is a bad picture, so don't think about that while I'm saying this, but there can be really good tenants. I was a tenant in an association before, early in my career, and I was a good tenant. So there can be good ones, but typically we hear about, as board members, the bad tenants, right? And so here's some things that you need to know about how to effectively deal with rental properties. First, in 2014, our legislature created a new law specific to how associations can handle and deal with rentals in their community. And first thing they said is, unless it's prohibited in your declaration, owners should be allowed to rent their properties, which seems pretty obvious to me, but they wanted to make that infinitely clear. So if your documents do not prohibit rentals, you are allowed to have, owners are allowed to rent their property. Number one. Number two, owners can designate third parties to act as the owner's agent with respect to all association matters relating to the rental unit. So if you have an owner that lives in Canada or maybe the Midwest, they can have an owner's agent, which might be like a property manager, handle all of their affairs, and they can request that we only deal with their agent. Now we continue, as the attorney for the association, we suggest that you continue to communicate with both the owner and the agent so that there's no information gap between the two of them. The associations are prohibited from requiring any owner to disclose any information regarding a tenant other than the following. So basically what this law did is it said, associations, you've been asking for way too much information about these tenants. We're limiting you now to just these few categories of information that you can ask a landlord for about a tenancy that they have in your association. Number one, we can ask for the name and the contact information for any adults occupying the unit. So we can only get the name and contact information for adults, no children. The time period of the lease, how long is this lease, including the beginning and ending dates of the tenancy. And third, a description and license plate numbers of the tenant's vehicles. That's it. That's all we can ask the landlord for information regarding their tenancy under Arizona law right now. Regardless of what your documents state, the law went on to say that the association is prohibited from doing any of the following. We cannot require an owner to provide the association with a copy of the tenant's rental application, their credit report, lease agreement, rental contract, or any other personal information, except as we talked about on the previous slide. We cannot require the tenant to sign a waiver of their rights, limiting their due process rights as a condition of the tenant's occupancy of the rental unit. Honestly, I don't even know what that means. Because I can't even imagine that any of my clients would ask for a tenant to waive their due process rights, just way out there, but our legislature sometimes is way out there. Prohibiting or otherwise restricting an owner from serving on the board of directors based on the owner not being an occupant of the unit. This doesn't belong in this rental law, but it got in there. So just so you know, if your bylaws say you have to live at Clearwater Hills, meaning reside there, or else you cannot be on the board. Well, that's contrary to what this law says. So recognize that I have a couple associations right now in the East Valley that I brought this to their attention that, hey, listen, you need to be careful. If you have people that don't live on the property, maybe they're a landlord, maybe they're, out of state most of the year, we cannot prohibit them from serving on your board. The next thing that the association, or that this new law set up was, we can charge $25 to process a new tenant. So for some of you sitting here, you might be like, oh yeah, we didn't know about that, right? But for most of you in here, you may have been charging $100 before this new law went into place. And so just know that if you're not charging it, you certainly have the right for each new tenancy to charge the $25. If you're charging more than $25, you need to scale it back to $25 so you're in compliance with the law. If the owner just totally blows you off, what's your only remedy? You can charge a $15 late fee. That's it. Okay, so this law has no teeth for the association. I suppose you could go to court to try to get them to provide the 3 categories of information, but I mean, come on, it doesn't give us anything. It's just the adult, the license plate numbers, I mean, how long the tenancy is, it's not that helpful to us. Any attempt by the association to exceed the fee authorized by this bill now voids the fee. So if you're trying to charge $28 or something to process the rental applications, if you're trying to do that, you can't charge anything, not even the $25. So this law was very, very one-sided. I'm surprised that more people aren't upset about it. In my opinion, most associations aren't following this. So just be mindful if you're asking for information about your tenants. These are the only things that you can ask. You cannot make it a requirement for the lease. So if you are doing that, just know that that's potentially, a violation of the law. You can ask for it, but you can't make it a requirement. Okay, let's talk about some hot topics in rental properties. Especially when we had the Super Bowl here, and with the Waste Management Open and all the all-star events that we sometimes get in Arizona. People are putting their homes on what we call Airbnb and vacation rentals by owner. For those of you who may not have heard of this in the past, it's basically an online service that allows owners to place their home in the rental market for typically short periods of time, a week, a weekend, a month. This is a very, very, very hot topic right now in community association law. Well, the first question you have to ask is, if you have an owner that's doing this, is it a violation of your documents? Do your documents prohibit short-term rentals? So that's the first question I would ask. The second question I would ask is, does your city, town, or municipality limit how long people can rent? Because there are many city, towns, and municipalities that say the minimum rental period is 30 days. And so if you've got somebody who's doing one of these services, and these are an online service with a website where you can go in and look at the pictures of the homes and then rent them for whatever time period you want under the calendars that they have posted. So first, what do your documents say? Second, what does your city, town, or municipality say? Third, if they're in violation of either, if they're in violation of the city, town, or municipality, pick up the phone and call code enforcement. Before you do that, take a screenshot of the property on these 2 things, because I've had this happen where we'll send a letter to an owner and bam, they take it down. So all of our evidence just went right out the window. So before you send the letter, before you complain to the city, town, or municipality about the violation, take a screenshot of the prior rental page and the current rental, the projected rental for the property, and the pictures of the property, the whole deal. You probably only need 5 pictures. You can use your cell phone to do it. If the owner is renting their property, and I think one of my clients is here today, we just talked about this. Sometimes when the owner rents the property, and if it's against your documents to rent, sometimes the owner will say to the tenant, shh, if anyone asks, you're my brother. Or we're friends. My friends will be renting the property all along. And we recently had a situation with an association in the West Valley where we had to kind of go undercover a little bit to find out, because it wasn't on vacation rental by owner or Airbnb, but we had a pretty good idea that this person wasn't, their brother. And so we had somebody knock on their door and just say, hey, welcome to the hood. We were just wondering how long you're going to be here, and we just took some questions, led to other questions, and they said, oh yeah, I'm totally renting. And so we got the position of the person before without going to them saying, did you know it's against the law? because that person then might kind of, put their back up and not tell you the exact truth. So these are complicated situations. You may want to have your attorney write a letter to the landlord. Their first response can be, I'm not doing it, or wasn't me. But I had a lawsuit once where the owner claimed that they were not doing short-term rentals using vacation rentals by owner. We knew they were. We had the proof with the screenshots. But then after the lawsuit was filed, we subpoenaed vacation rental by owner, and we got all the rental records. And they were busted. They ended up putting their property up for sale. So keep that in mind. Some of you, the topic of rental restrictions is starting to come up again, where people are asking us questions about, well, can we write something in our CC&Rs that would prohibit rentals? Or can we write something in our CC&Rs that would prohibit Airbnb or vacation rental by owners? Of course, we're doing amendments for many different associations on these topics. We have to be very careful if you're a condo, because under the Condominium Act, in order to change the use of the property, we need 100% approval of the membership. Now, everybody sitting here, I can't even get people to do 100% when we're giving money back. So this type of an amendment would be difficult. So keep that in mind. If you're a condo, we need to strategize a little bit about whether this is even possible. If you're a planned community, typically this can just be done through an amendment to the CC&Rs. Although I will tell you, these amendments are controversial. So you'll want to talk it through with your membership before you take it out for a vote, because maybe the members won't support this, and it turns into a real divisive, nasty thing if the members don't support it. Let's see some questions that you can ask. I have these on the back of the cheat sheet. Can renters attend board meetings or be a designated agent? So it's up to the board. If you want to allow a renter to come to your board meetings, that's certainly your prerogative. You are not required under Arizona law to allow a renter to come to your board meeting, okay? If the owner makes the tenant the designated agent for their property, we do have to allow the designated agent, and that person would have to be appointed in writing. We do have to allow that person to attend the regular board meetings. So if they're the designated agent in writing and they're the tenant, you bet they can come. Can renters vote? No. Not even if they're a power of attorney, okay? Only the record owner of a property can vote. How can we get the compliance of a renter? This is always fun. I like this almost as much as I like collections. So what's the best way to deal with the landlord? Okay, after 20 years of experience, I can tell you, the best way to deal with the landlord, with a bad tenant, is to make it hurt in the landlord's pocket, okay? The landlord is in this tenancy relationship because they want to make money, okay? And if they start to get a bunch of fines for the behavior of the tenant, this is not a good situation for them. They're starting to lose money. And what we typically will do is if we have a bad tenant, and I had a really bad one in an association in North Phoenix, that the tenant ultimately ended up burning down the condo. Horrible. And just to rub salt in the wounds here, after the tenant burned down the condo and the 2 units next to them, thank goodness nobody died, now they're suing the association because they don't like the repair work that the association's insurance company did, okay? So if you're feeling bad about your association before you walked in here today, I bet you're feeling a lot better. Okay, so what's the best way to get the compliance of the renter? Fining the renter, or finding the owner for the renter's behavior, very good strategy. Another strategy that we do with really bad tenants is I pick up the phone and I call the landlord. And the call typically, will go something like this. Hi, Mr. So-and-so or Mrs. So-and-so. I'm Beth Mulcahy with the associations. I'm the association's attorney, and I've been asked to reach out to you regarding your tenant. And usually what they say to me is, I don't know why the association's picking on me. I'm lucky to have this tenant. She says she's not having wild parties. We got a bunch of people who are crotchety and crabby there. They get mad when there's a party at 5:30 in the afternoon, right? Okay, so then I'm listening. And then I say, well, here's the evidence that I have. you know, and maybe I'm emailing them pictures while we're on the phone of, 2 a.m., 6 squad cars, beer cans, I can't even tell this next, it's too bad, but we've had some weird stuff that we'll find debris after the party. And so I'm emailing it to them, and usually by the end of the call, the landlord is saying to me, "Can I hire you to evict the tenant?" And so that's kind of what we want to do. We want to have the evidence, we want to be fair, reasonable, but we want to say, listen, landlord, this is going to cost you. If you let this situation continue, this will cost you money. And we will go, our final push is we'll go to the court and we'll ask the court to order you to evict the tenant. So that's an effective strategy. Remember also too that tenant or landlords are required to register their rental properties with, under Arizona law, must be registered with the county where the residential property is located. So if you think one of your landlords hasn't registered their property and they're not paying taxes if they haven't registered, you can, go in and narc on them. And I can bet, sure as I'm standing here, the county will investigate it because they don't want to lose that rental tax information, or income. So keep that in mind.